Okay, we're ready to get started.
Yes, as I said, I do have two more witnesses to call. I expect they'll be denied, but I want to make a record. I would like to call Trustee Blakeman to the stand.
Okay, counsel?
I object to that. The trustees are the decision makers here. They are the fact finders. They are not proper fact witnesses in this context. Asking them to testify is akin to asking a juror to testify, as well as the judge to testify. In addition, Ms. Blakeman in particular is a named defendant in the civil suit, and if she were to testify today, she wouldn't have the benefit of her counsel defending her regarding, matters that could intersect with that other legal matter. And for that and the reasons previously stated, I object to that.
Counsel?
Yes, I agree. It would be like having a juror testify, just like it would be having a juror be sitting there who has given the finger to a plaintiff's husband. So I do believe that it is relevant. The information I would offer proof is that Trustee Blakeman has some important information regarding factual issues, how often Sergeant O'Keefe got a haircut on duty, whether they in fact discussed official business, as Mr. Duffy just testified, and other matters of relevance in terms of disparate treatment.
Okay. The trustees have considered this, and the trustees' position is that any testimony that you could elicit is irrelevant to the claims in the proceeding. It would be akin to having a juror or a judge testify, and thus would create challenges with issuing a decision in this case. Additionally, the proffers that Trustee Blakeman made an obscene gesture at a non-party. I understand he's related to the party, but it doesn't relate to the claims in the appeal that is under consideration, so the request is denied.
Okay. The next proffer I would like to make is I would like to call Trustee Khan to the stand. And do you want to object before I go into my reasons?
I have the same objection. I also object to the relevance, for all the reasons stated in our evidentiary discussion yesterday.
Okay.
Yeah. My offer of proof is that Trustee Khan has some important information regarding the underlying incident that was part of this case, which is the sharing of videos. He was the subject of it, and my offer of proof is that he could testify that there were indeed issues surrounding the who was at fault, and that is proven by the fact that he, in fact, requested dismissal and received dismissal from Corporal Murphy of his ticket subsequently, and there was also issues around whether he had asked Chief Swanson to dismiss his ticket, and that perhaps those reasons could underlie some of the accusations against Chief Swanson regarding his sharing of the information.
Counsel?
Same objection that all of this is far outside the scope of, this is all post-dating the trustee's decision. The actual communications between Mr. Swanson and Attorney Selden are in the record. The underlying details of the incident are not relevant. None of the proffer Attorney Frass has offered is relevant to whether Mr. Swanson should be removed from his position of chief.
The trustees have considered this, and their perspective is that the underlying basis is irrelevant. It was not part of the employee discipline. Yesterday, I allowed in the law enforcement expert report of the underlying incident, or excuse me, not expert report. There was a law enforcement report of the underlying incident. It was just for the limited purpose of exploring the manager's awareness and state of mind and intentions regarding what he learned at the time. That was subject to exploration in his examination. But the underlying incident itself has never come into evidence, and so the trustee's perspective is that it is not relevant, and thus the request to have Trustee Khan testify is denied.
Thank you. We rest.
Thank you.
We have one witness to call in rebuttal via remote testimony. His name is Lou Dekmar. He is an expert.
Okay. The folks that operate the technical stuff have asked to take a quick break so that we can arrange to have that happen.
I'm fully in support of that.
Okay, so let's do that, and when it's ready, then we'll begin.
Can you please spell the name of the witness?
Yes, his name is Louis Dekmar, Louisdekmar.
Can you spell that again? I'm sorry.
Sure, Louisdekmar.
Okay.
And another matter, I guess, before before we have him testify, Mr. Mello's affidavit was admitted into the record over my objection. I'd asked for a ruling that Attorney Frass be prevented from cross-examining Mr. Dekmar. We did not get to cross Mr. Blish or Mr. Mello. We could have just asked to put in an affidavit, but we'd like the trustees to be able to see and hear Mr. Dekmar. Although he is not physically present in Vermont, he'll be present remotely. And this is rebuttal evidence, and I think that's appropriate under the circumstances. So we make that request.
Okay. I would like to hear from you, Attorney Frass, but I think, well, go ahead.
Again, this is just an opportunity to try to prevent evidence from coming before the trustees if I'm not allowed to cross-examine a witness. That's all I have to say.
Okay. We will take it under consideration. We will discuss while we're on a technical break and address it when we return.
Thank you.
Thanks. No. Oh, yeah, we got a rule on that. Yeah,
Yes,
okay.
yes.
The trustees are going to permit cross-examination if desired.
Oh,
after
okay,
this.
great, thank you.
Thank you.
Understood. Could you state your name for the record, please?
Yes, Louis Dekmar, D-E-K-M-A-R.
Where are you physically located right now, Mr. Dekmar?
And before,
Presently at my residence in LaGrange.
We need to swear him in.
gotta swear
Oh,
on
I'm
this.
so sorry. Do you want to do that?
Yeah, I should just do that.
Sorry, before, well, I'm sure you're.
Oh, I need to be
Yes,
sworn, don't I?
Mr. Dekmar, Brian Monahan here. Please raise your right hand. Do you solemnly swear that the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you.
So now that you've been sworn, could you state your name again? I'm sure a lot have changed since we started, but.
Yes, Louis Dekmar. I'm located at my residence in LaGrange, Georgia.
Did you provide a copy of your CV?
I did.
Thank you.
I'd like to move to admit Exhibit M219. I'll represent this as a copy of the CV Mr. Dekmar provided.
Okay. All right.
Okay.
M219 is admitted.
Thank you. I'll come to you. Come over there. Sorry. Thank you. Mr. Dekmar, does your CV accurately reflect your education, training, and experience?
It does.
I'd like to ask you to highlight a few things. Do you train new chiefs?
I do.
In what?
I conduct. In Georgia, there's a statute that requires newly appointed police chiefs within a year to obtain 60 hours of executive level training. And I conduct a 4-hour block of leadership and management for newly appointed chiefs, and have done so since 1994.
How many chiefs would you estimate you've trained in that process?
In excess of 2,500.
How many disciplinary actions have you been involved in?
It's probably somewhere in excess of 700.
What kinds of disciplinary actions at a high level have you been involved with?
As department head for the police department, and then for 13 years for the fire department as chief of public safety, so I had both. It would be anything from terminations to suspensions, usually over 5 days, suspensions under 5 days, battalion chiefs and captains were responsible for, but then I would hear those appeals. I also served on the city appeal board, which heard appeals outside of the department for all the departments in the city, except for the ones that I was directly responsible for. and I served in that capacity for, I think, 27 years.
We've heard the phrase today, internal affairs. Could you explain to the trustees what the phrase internal affairs generally means?
Internal affairs is the responsibility the agency has to conduct inquiries and investigations into allegations of misconduct by its employees. And it's generally viewed as an administrative investigation to determine whether or not the employee acted within or outside of policy and standards of that particular agency.
What is your experience related to internal affairs?
Whenever you start, it's very faint, and I catch the last half of your question.
What is your experience related to internal affairs?
I was an investigator with the prosecutor's office and was asked from time to time to conduct internal investigations that could or may not reach the level of criminal conduct, but then would result in some administrative review. As a captain, I was responsible for the internal affairs function for about 4 years. And then as police chief, I was responsible for the policy and the execution of internal affairs investigations, which in the course of my career was probably somewhere around 500 or more internal affairs investigations.
Have
In
you,
addition, I've taught a 40-hour internal affairs class for the Georgia Department of Public Safety Training Center. And I also was responsible for an 8-hour block of internal affairs training for police chief and command staff. In addition to that, I conducted training for the National Internal Affairs Association and several classes for the Georgia Internal Affairs Association.
what is the Commission on Accreditation for Law Enforcement Standards?
Actually, it's the Commission on Accreditation for Law Enforcement Agencies,
Oh, excuse me.
known as CALEA. And CALEA was formed in 1978 by the 4 major executive law enforcement organizations: the International Association of Chiefs of Police, the National Sheriff's Association, the Police Executive Research Forum, and the National Organization of Black Law Enforcement Executives. During the 70s, there was a lot of controversy around police misconduct, training, requirements, standards, and those 4 agencies got together, created the commission, and it was charged with developing law enforcement standards for agencies. Since that time, those standards have been modified to reflect accepted practice and best practices nationally and internationally. There are some agencies that are accredited outside of the United States, primarily Canada, some in Mexico. There's currently a little over, I think, 480 standards, and they cover the 3 pillars generally that law enforcement executives are responsible for, which is management, administration, and operations. I served as an assessor, which goes into the agency, looks at those standards, looks at the way the agency conducts business, and determines and reports to the commission on whether or not there was client compliance demonstrated or issues identified surrounding compliance.
Have you ever had any role as a commissioner yourself?
Yes, after serving for about 10 years as an assessor, I was appointed to the commission, which is 21 individuals that are appointed from elected officials, the Supreme Court justices, state Supreme Court that is, to practitioners, academics, and elected officials. And in reviewing standards or creating standards, it allows you to get the view and the needs from those various constituencies in order to develop a standard that would be most useful to law enforcement agencies. So I served in that capacity for 10 years, 5 of those years as the chair and president.
What role, if any, do you have with the commission now?
Once I completed my term in your cap, after 3 appointments, I went back to assessing and currently continue to assess agencies.
Have you done outside audits for agencies?
Done a number of outside audits, management audits, or bad outcome reviews that are requested generally either by the political body, the city manager, or in some instances, the police chief who wants to be proactive and wants an outside look at their agency.
When you do an audit, how are they conducted?
Generally, the individuals that are interviewed, and generally the way an audit goes is primarily based on interviews, review of the policy, and then review of the records that would indicate whether or not those policies were reflected in the day-to-day operation of the agency. And so it would be a combination of interviews and record reviews.
Have you ever been a city manager?
I served in the role of an acting city manager for several months, and in that capacity was responsible for the day-to-day operations of the jurisdiction.
Have you ever been qualified as an expert in state or federal court?
Yes, I participated in, I think, over 40 cases and where I offered expert opinions, and in the cases were frequently deposed, and on some occasions had to appear in trial.
Can you hear me? Hear my question now?
Okay.
Have you been retained as an expert in this matter?
Yes, I was contacted last week.
What were you asked to do in this matter?
I was asked to review the record and determine whether or not then Chief Swanson's actions were consistent with accepted law enforcement practices and standards.
What documents did you review?
I looked at what was sent to me, looked like the entire record of the hearing and the testimony that was associated with that. In addition, I received a lot of the background documents that led to the discipline, primarily I think the letters and notifications from the city manager, the outside report that was conducted that generated the interest of the city manager and resulted in the disciplinary notice.
Did you review the trustees' first decision?
I did in their findings.
Did you review Mr. Mello's affidavit?
I did.
What is the standard you consider when assessing potential discipline?
Well, the standard is a preponderance of the evidence. So you look at the allegation, you look at the policy, and then you look at the practice in the agency, and then whether or not, based on the standard and the practice of the agency, the behavior or performance issue deviates from that. And if it deviates from that, then you look at the nature of the discipline, whether or not that discipline was consistent with accepted standards and practices.
Are you familiar with the Vermont Criminal Justice Council?
Only with regard to the references that were made in the record. Generally, it appears that it's very consistent with what is known as POST and other jurisdictions or other states, which is the Peace Officer Training and Standards Council, which is responsible for the certification, standards, and under certain circumstances, conduct of the officer. Generally, the way it works is the power to arrest and act as a law enforcement officer comes from those sorts of agencies, but the ability and the authority comes from the agency from which you are employed. So you get the power to arrest from the state, but you get the authority to arrest being a sworn officer in whatever jurisdiction.
Have you ever reviewed misconduct cases through Post in Georgia?
Yes, in Georgia, the post councils segmented into 3 areas: standards, certification, and probable cause. And probable cause looks at misconduct cases. And so I served on the probable cause committee, which looked at roughly 1,500 cases a year. And of those, we would take revocation actions, that is, take away arrest powers for law enforcement, around 250. For the other personnel that are certified, either jail or correction officers, probably another 200, 250. So we would have revocations somewhere between 450 and over 500 a year.
Do you agree that the standards for removing arresting authority or certification differ from employment standards?
Yes, the standards for post to intervene is going to be serious misconduct that jeopardizes or compromises something related to those state standards. The agency standard is going to be defined by the jurisdiction's policies. In the case of a municipality, it would be the agency policy, the police department policy, and the city policy. You can, as I indicated, we looked at 1,500 cases, and a number of cases we didn't take any action on because these were administrative violations and did not rise to the level of post involvement.
But in those cases where you did not take action, the employee was nevertheless removed from their position or terminated from their position as an employment matter.
Yes, in some cases that's certainly true. In fact, in cases where I have terminated folks, you're required in the termination to submit that to post, but that does not result in a revocation of arrest powers. I've had a number that have gone on to other agencies after they've been terminated with ours.
Can you hear me? What is your opinion regarding whether the conduct of Mr. Swanson met accepted standards for police chiefs?
Generally, looking at the testimony at the hearing primarily, which was my focus, I looked at the record because it was under oath. Additionally, there was the opportunity for cross-examination. And based on the review of that record, I found the conduct generally outside and contrary to accepted law enforcement standards and practices that you would expect from someone that's an agency head.
What? I can see that you're not hearing my question. Can you hear me now? What is your opinion regarding the external investigation conducted by Mr. Burgess?
I reviewed that in a cursory fashion. My focus was on the patterns that were developed that were sufficient for the city manager to notice at the time Chief Swanson, and then the record that was developed during the hearing. But I felt like, the investigation identified, adequate trends. I found the review by the city manager not inconsistent with my experience, which is there'll be a number of findings in an investigation, but I may not always agree with them as chief, so I don't include those in the disciplinary notice.
I want to break down a few topics.
I can't hear you.
Oh, sorry. Can you hear me now?
Now I can.
I'd like to break down a few topics with you. You talked about the pillars of policing earlier. What are the general responsibilities of law enforcement agency chiefs?
Generally, there's management, operations, and administration. So management is kind of marrying the resources with the personnel and those responsibilities. Operations would be the things, the activities that they do every day. Police officers going to call, police officers making traffic stops, dispatchers dispatching, record clerks providing reports to citizens. So the operational tasks. And then the administration is the paperwork side. They're the ones that make sure that there's documentation for any state mandates, for federal mandates, record keeping. Also, the policies of the agency would fall under administration, how you administer the agency. So you take one function, for example, training. That could be operational. Okay, the person that actually physically is doing the training. So ensuring that training is done properly, and they ensure that they're certified, and the people doing it are certified, whoever's charged with that responsibility. The management side of that would be scheduling everybody so they're able to do the training. And then the administrative would be the record keeping. So these different responsibilities or tasks in an agency generally aren't siloed in one of those pillars. Leadership's responsibility then is kind of like an umbrella over all three. And they use the leadership elements that all department heads have, which are, okay, selection, who are you selecting to do the task, or who are you selecting when you hire them, or who are you selecting when you're promoting folks? Is it a good fit? Are they going to be able to do those tasks? And then is there adequate written directives or guidance to ensure that those tasks are done in a way consistent with the standard of the agency? And then the third is there adequate training so they can do those tasks? And then after that is supervision. Are there adequate supervision to ensure that there's monitoring, and if something's going a little bit awry, that there's a gentle tap to get it back into the lane where it needs to be? And then after supervision is accountability. And in some cases, that includes discipline. And then you look at the sixth element is going to be outcomes, or you look at your outcomes or your feedback to ensure that those things you're doing don't call for an adjustment in policy, practice, or training. And then finally, are you reviewing your practices and your policies through a lens that is ensuring that various changes in the environment are incorporated in your written directive and your practices and your training? So is there a change in statute? Is there a change in practice? Are you bringing new technology in? Are you making those adjustments as it relates to training and written directives?
Can you hear me? Can you hear me now?
I can.
Okay. What happens when in your experience, are subordinates generally reluctant to make complaints about their superior officers?
Yes, that's not unusual generally, and it's kind of enhanced in a law enforcement operation because we're paramilitary. And as a paramilitary organization, there's always some trepidation or apprehension about going around someone that you report to share a complaint with someone that perhaps outranks that individual or is in a position to address it. Which is why, in leadership, you've got to create as many opportunities to get feedback as possible, because folks are reluctant to share information with you, particularly if it's negative.
Next question. Can you hear me?
Mm-hmm. Yes, ma'am.
Why do police officers wear uniforms?
Well, the basic is to be easily identifiable. And the other is to characterize and portray a professional appearance. There's a number of reasons. One is that it instills confidence when people see folks in uniform, see they carry themselves well. That's why, for example, you see pilots that the way they walk, the way they carry themselves, even inside they're wearing a cap, they're wearing a jacket, they're wearing a tie, because when folks put their trust in someone and their safety in someone, they want reassurances. Part of that visual reassurance is how you attire yourself. There's also some literature out there that indicates that the way you carry yourself, present yourself, wear your uniform, inhibits folks resisting arrest. They're more likely to acquiesce. So it's a number of reasons, and historically, we've been uniformed since the creation, or what's been recognized as the creation of law enforcement back in 1829.
Can you hear me now? Can you hear me?
I'm sorry?
Can you hear me?
Yes, go ahead.
Okay.
Yes, now I
I'm
can.
gonna just try and make sure you can hear me so that you can hear my complete question.
Yeah, I think you have to maybe talk a few seconds and then it starts picking up. So if you have some kind of preliminary something, that'll help.
I'll vamp for a few seconds so I can get you to come on.
Thank you.
Why, if at all, is it important for police officers to share the location with each other?
Well, a couple of reasons. One is dispatches, of course, when you're sharing a location, they're monitoring where you are. And so when they're dispatching calls, they can identify those units easier and quicker that may be closer to the call. And likewise, the responding units know who's closer, who's available. In addition, for officer safety reasons, so that you don't hop out on a traffic stop without calling in, because if something occurs, you are only able to transmit that you need some assistance. If they don't know where you're at, it's difficult to do that. So that's generally why you keep your location and you notify folks where your location is going to be.
I have another question for you. Can you hear me?
I got it. Go ahead.
How does what you just said relate, if at all, to Mr. Swanson's organization of the officer in charge?
Yes, that was an issue I saw in the review, and that's just a basic management or leadership responsibility. In your absence, who's in charge? In my particular case, I had 3 captains, and they would get together every year, and they would lay out a schedule and submit it to me, and I would approve it. But what it did is it put responsibility, if I'm unavailable or on vacation or not around, where that responsibility lies in the chain of command, and lets everybody know they're acting in my stead if I'm unavailable.
Are you ready for the next question? Can you hear me now?
Yeah.
Why, if at all, is it important for police officers to fulfill training requirements?
Training is the fundamental responsibility of any agency. We're tasked with a lot of responsibilities, many of them what are characterized as critical tasks, meaning that if they're not performed properly, a citizen is injured. And by injured, I mean they suffer a loss, whether it's how you handle those responsible for that are affected by mental illness, property and evidence, use of force. So generally, and this is where POST comes in, or in your case, your criminal justice oversight agency in Vermont, is they have minimum standards. So those are like the basement standards that you have to achieve in order to ensure that you maintain your powers of arrest or your license or whatever that authority issues in order to perform as a law enforcement officer.
Assuming with me, if you will, that Mr. Swanson was willing to permit officers to slack on some training requirement. What is your reaction to that?
Objection. There's no evidence foundation for this.
This is an expert.
And there's supposed to be rebuttal testimony, and there's nothing that this is rebutting in terms of what was presented in our case.
I do believe that training was at issue. It at least was issue in the last hearing.
And it's
Right, but if we're providing you based on the last hearing, that wasn't allowed, and we're into rebuttal territory now, which is very different than presenting something from scratch.
If I may, this is also rebutting Mr. Swanson's affidavit where he commented on the trustees' findings regarding training.
There was no evidence about that. There was nothing ever charged against Chief Swanson that he allowed unsupervised officers to be in the field. That was absolutely not an issue in the hearing. And somehow it appeared somewhere, but there was nothing related to that that was charged against him by Mr. Duffy or anyone else.
Can you direct us to his affidavit by chance?
Yes.
The affidavit is contesting the things that were in the decision that had no foundation. The reason that the affidavit was stated was because something was included in the decision that had no factual foundation. So now using that against him, that he's contested that there was no factual foundation for this original finding, and now using it as evidence, somehow rebut, it's not making any sense.
Okay, let's see where it is in the affidavit.
Here we go. It starts on page, paragraph 37 and continues until paragraph 40.
I'm sorry, could you say that one more time?
Of course, it starts on paragraph 37 of Mr. Swanson's affidavit. He
Number 3.
provided information about his response to the trustee's decision. And I guess I will also point out that in my summary of evidentiary objections, I respond to these particular paragraphs by highlighting the testimony from Mr. O'Keefe that directly related to these training topics. They're cited, I can give you the pinpoint cited if you need.
Please do.
Okay. Those are on the first hearing transcript, page 196 to 198, 196.15 to 198.5, and 198.16 to 199.11.
I'm sorry, can you repeat that?
Yes, 196, line 15 to 198, line 5, 198, line 16 to 199, line 11.
All right, give us a moment, please.
Understood.
And I'm sorry, in Chief Swanson's affidavit, which paragraph are you referring to?
Beginning with paragraph 37, there's a section titled Allegations Allowing Under-Trained Officers into the Field.
What was the transcript once again?
The transcript is 196,
I'm sorry, what?
196,
Got it.
line 15 to 198, line 5, 198, line 16 to 199, line 11.
What was the line in 197 or 198? It was 196, line 15 to 198, line.
I'm sorry, I keep just turning my page. 198.16 to 199.11.
Thank you.
Can we go deliberate for 2 minutes, please?
Yeah.
For that.
We're gonna go on a break. You can just keep yourself on mute. We're taking a break.
Oh, okay. How long? I didn't hear.
It'll be about 5 minutes. 5 to 10.
Okay, thank you.
Thank you.
Stand. So the objection's overruled and the question can proceed.
Mr. Deckmeyer, are you there?
Oh, there it is.
Can you hear me?
Yes.
So before we took a brief break, I asked you a question about assuming Mr. Swanson was willing to be lax on some training requirement. What is your reaction to that?
Training is a
Objection
fundamental
again.
responsibility of an agency.
Noted.
Sorry. There was an objection. You can continue.
Yeah, I can't hear, so if you'll just do this when there's an objection, okay, and then I'm gonna stop. I apologize, it's just not coming through.
It's probably something with Zoom, but you can answer my question. Do you have it in mind?
Yes, so Yes, sir, ma'am. So training is a fundamental responsibility, and as noted in my CV, I do a number of expert witness cases, 1983 civil rights cases, and one of the foundations for successfully getting either a summary judgment or a motion to dismiss is the training history of the agency. And so when I think it was the acting chief at the time testified that he didn't complete the use of force training but signed anyway, to me that's a significant red flag.
Assuming Mr. Swanson, can you hear me? Can you hear me? Assuming Mr. Swanson chose not to go to court on at least one occasion, what is your reaction to that?
That's contrary to accepted law enforcement practices and standards and a basic responsibility of any police officer. What was particularly troubling is from time to time you have officers miss court, they forgot, it fell off their plate, but to intentionally just particularly tell somebody in the agency that they get a freebie, in my opinion, that's a significant violation of standards.
Assuming Mr., can you hear me? Can you hear me now?
Go ahead.
Okay. Assuming Mr. Swanson used the F word to refer to other employees on at least 2 occasions, what is your reaction to that?
Objection, to refer to other employees in conjunction with discussing, perhaps referring to, is a little inflammatory.
Could we have some more foundation on that?
Sure, let me
then we can-
get the exact quotes. One moment. Oh, it's in my. Can you hear me?
Yes.
Assuming in reference to, in conversation with one dispatcher, Mr. Swanson said in reference to another dispatcher, pardon my language, quote, "Tell her to stop fucking calling me," end quote. What is your reaction to that?
That would be contrary to the standards of someone that's an agency head. If whatever the issue was, the way they notified or notifying the chief inappropriately, then if it's outside the bounds of policy, then it's handled as a policy issue. If it isn't, then it required clarification and guidance as to when the chief's notified. But that would be an inappropriate way to engage another employee about still another employee.
Assuming Sergeant O'Keefe, when Sergeant O'Keefe told Chief Swanson that folks in the department were upset that he was not attending a meeting with agents from Homeland Security, his response was, again, pardon my language, quote, "Fuck 'em, I don't care," end quote. What is your response to that?
Police officers aren't shrinking violets. They're not a gallery of nuns. So that language in and of itself from time to time, doesn't raise a particular concern. But if as an agency head, you want folks to come to you and let you know what is influencing tone, morale, perception, then if you want to invite that, and if you respond that way, what you do is you deter. I think a sergeant in that case would be second or third in command, depending upon the rank structure. You deter those folks from bringing news to you. And so it creates a barrier that I think interferes with, the effectiveness of someone in a leadership position.
Assuming Mr. Can you hear me? Can you hear me now? Assuming Mr.
Yes.
Swanson failed to do a death report for several months, what is your reaction to that?
Reports are a fundamental duty. Those aren't just the chief's duty. Those are a duty that every police officer has a responsibility to complete. Generally, the standard for most agencies in patrol is that before you leave, you document the event in a report. Some agencies give you more leeway than others. But in a death investigation particularly, even as unattended, what we call an unattended death, that is, it's a natural cause death, depending upon the circumstances, the physical evidence present, a family member finds them and, there may be some sort of artifacts of post-mortem, what appears to be injury when in fact it isn't. And the quicker you get those investigations done and reassure folks that, this really is a natural death or this is a non-event, the easier it is.
And shoot, looks like the internet may have, Mr. Deckmar's frozen on my screen.
It was amplified.
I'm sorry,
And
Mr.
so-
Mr. Deckmar, I'm sorry, the internet cut out for a second.
Where,
Can you, you were,
Easier.
you were saying reassure the family, maybe?
yeah, so you get the report done so you can share the findings with the family and explain any concerns that they have. It's not unusual, and I've had this on more than one occasion, where a family member from somewhere else thinks that there was something bad that happened and it's being covered up by other family members and they have concerns, and so you want to have that investigation complete to address those concerns. The other issue is, of course, the police chief models the standard. People look to them to ensure that what the policy says really applies. So actions speak louder than words. And if you're not doing those most basic police tasks, and then you try to hold other people accountable, they're going to point to your conduct as an alibi for their conduct. And so, it's very important when a police chief's involved in any incident that he understands he's modeling his behavior for the others and setting the standard for the others in that agency by how he comports himself and the practices that he embraces.
Is that sometimes referred to as normalized, can you hear me? Is that sometimes referred to as normalized deviance?
Yeah, normalized deviance is when policy begins to distance itself from practice. And so over time, because of the false feedback that people in the organization get, you can take these shortcuts or you don't have to respond in a certain way and there's no consequence. And pretty soon, there's a wide gulf between practice and what the written directive is, which really becomes problematic when there's a bad outcome that results in litigation. Because the history of the agency and the documentation in the agency is either going to acquit it or it's going to indict it. And those actions or those lack of enforcement for the policy play out in those kind of litigation scenarios.
Can you hear me now for the next question? Can you hear me?
I can't hear you.
Can you hear me now?
Not
How about-
good.
Okay. Did you review the town manager's instructions regarding Mr. Swanson's administrative leave?
I did.
Did you review Mr. Swanson's communications regarding training records?
Yes, to acting chief of chief, I believe.
And did you review the testimony from the employees who reported feeling threatened and uncomfortable when Mr. Swanson came to secured areas of the police department?
Yes, I did.
What is your reaction to that incident?
Well, I think on the initial permission to get there, my understanding is that based on the record, that then Chief Swanson was advised not to go to the police department unless he received specific authorization, and that was to come from the city manager based on the tenor of the record that I read. But he did send a request to the acting chief, and the acting chief said okay. And so I would interpret that as authorization. I think for clarification, what the acting chief could have said is, okay, let me check with the city manager. But in essence, I think he got approval to go into the police department in order to get his training records. What's confounding is, on unnecessarily interacting with the other employees there that in the record indicates secure areas. In interacting in a way that, gave them pause or concern or felt threatened or uncomfortable because of the way he issued or dispersed letters of the finding by the Vermont Criminal Justice Agency. And so I found that to be inconsistent with what the expectations were when you're placed on what in essence is administrative leave. When I put folks on administrative leave for an investigation, they don't come to the police department unless I authorize it as the police chief. And they'll contact somebody maybe, and then they'll get a hold of me and I'll say, yeah, no problem. But usually then they're also escorted, and just to make sure that, there's no issue. And so I found that contrary to what you would expect in a department head.
Is it appropriate, can you hear me? Can you hear me now?
Yes,
Is
ma'am.
it appropriate for a police chief to share videos of an accident still under investigation with someone outside the police department?
Not unless it's in the performance of their duty, and that's whether it's an active investigation or not. Usually there are policies that relate, and I think I saw one under the officer conduct policy for the agency that you're not supposed to, this sort of thing is confidential. And confidential means that unless you receive authorization from a higher authority or it's consistent with state statute, you don't disseminate that information.
Before I ask you a few final questions, what do you, can you hear me now?
Yes, ma'am.
What do you generally charge for your expert?
Work. Yeah. Yes. Thank you. It's $400 an hour.
Is that in line with experts, with your expertise?
Yeah, it's high bid point. Usually what I see is somewhere between 2 and just under 600 an hour.
Can you hear me now? Can you hear me now?
Yes, ma'am.
Mr. Detmar, can a department function well if there's a complete breakdown in trust between its leader and its employees?
It creates a very difficult situation because in those where the culture and the interactions are focused on each other and what's going on and picking sides and who do you believe and who you don't believe, that interferes significantly with effectiveness. And people should be externally focused on service and how do we improve service and what are our outcomes and how do we do a better job. And so if there are trust issues with the people that you work with, that oftentimes interferes with the ability to do the work because they don't trust each other.
Can you hear me now for the next question? How about now?
Good.
Do you agree that a municipal manager must be able to trust the chief of police's judgment on a consistent daily basis?
Yes, having served as acting city manager, you're totally dependent on your department heads. The department heads are the experts for those various responsibilities, and the city manager is responsible to ensure that they do their job by primarily looking at results. And the department heads, in my opinion, look at the city manager as a resource. If they're unsure about a particular duty, or they're hitting a stumbling block on something, or there's a fork in the road and they could go either way but not sure what the preference would be, then you have an obligation to go to the city manager for guidance and direction so that you ensure that your reading of whatever that issue is consistent with the expectations of the person that you work for.
Do you agree, can you hear me now? Can you hear me for this question?
Good.
Okay.
Yeah.
Do you
Yeah.
agree that the chief of police is one of the most visible municipal employment positions in the community, and that the job carries a lot of weight and expectations?
Yes, that's recognized. I mean, every city manager I've worked for has made it clear that second to the mayor, you're the most visible individual in the city. And what you say carries a lot of weight in terms of how people perceive the public safety issues, which is a primary responsibility of any jurisdiction. How the public sees the nature of public safety in their jurisdiction by the way the police chief comports themselves, what they say, who they say it to, and how they say it.
Can you hear me now for the next question? Can you hear me now? Can you hear me now?
Right.
Okay.
Yep.
Do you agree the chief of police must be a role model and lead by example, because employees are going to mimic what the chief of police does?
Yes, and I think I touched on that when I talked about some of the policy issues or some of the performance issues that were identified by the city manager. That what the police chief does is communicated very quickly in an agency. The smaller the agency, the quicker. But eventually, and I've worked in agencies with 10 officers to over 300. And it just takes sometimes longer for that to get out, but it's not unusual for, missteps or actions contrary to policy or good performance are identified and shared.
Thank you, Mr. Deckmar. I have no further questions for you at this time. Thank you for your time today.
All right, thank you.
Uh,
Ask him to stay.
Stay on, please, because Attorney Frass
Oh,
may
sure.
ask you questions.
Attorney Frost,
Sure.
Yes,
why don't you come up here?
okay, thank you. Hello? Can you see me? He's frozen. Frozen.
Oh, there you go.
Okay, I can hear you now. You froze for a second.
Okay, can everybody else hear me?
Yes.
Okay. Good afternoon, Officer, what should I call you? Is it Mr.?
Lou is fine.
Okay, good afternoon, Lou. My name is Linda Frost. I represent Chief Swanson. And I have some questions for you. You indicated
Yes,
that
ma'am.
you were paid $400 an hour. How much total have you billed for your services?
Yeah, I've not invoiced yet, but I've got somewhere, not counting the hearing that we're in, somewhere around 7 or 8 hours.
Okay. So not including today, that would be about $3,200.
That, I'll trust your math.
Well, my math, you shouldn't trust my math, so, let me think. Okay, I think it's right, okay.
Okay.
All right, you're in Georgia, you said,
Yes, ma'am.
and you've never practiced in Vermont, I take it?
No, ma'am.
And you don't have any particular experience with Vermont police practice in terms of how things work generally in the Vermont police system?
I had a couple of 1983 cases, and as a result of that, I, had an opportunity to review kind of reporting procedures and the policies of agencies.
So did you learn in those two cases that Vermont is somewhat less formal than some other places?
Yes.
Agree with that? Okay. In fact, these parliamentary standards that you were referring to, those aren't something that are found in Vermont, correct?
I'm not sure I understand what you mean by parliamentary.
I thought you were talking about things that were more like parliamentary standards in your directive. Did I misunderstand that? Parliamentary procedures?
No, ma'am. No, ma'am, I was talking about accepted law enforcement standards.
And one of those was the CALEA standards? Kalia agency?
Yes, ma'am. Yes.
You're aware that the Woodstock Police Department is not a Kalia agency, correct?
Correct, but those standards reflect general practices and recognized as general practices, whether you're accredited or not.
In Georgia, standards are in fact different than Vermont, aren't they?
When you say standard, are you referring to post standards?
Well, look, I can be more specific. In Georgia, police chiefs generally are considered at-will employees, correct?
It depends. Georgia's an at-will state, but I think over 90% of the municipalities, which are about I think there's 559, have some sort of due process as a part of their contract or their policies. I could only be relieved for cause.
So you haven't discussed cause at all in your direct examination. Actually, can I excuse myself for 1 minute? I need a tissue.
Yes.
Yeah.
Thank you. The Zyrtec did not work. Okay, I'm back. I'm sorry. I was talking
No
about.
problem.
Okay, so you didn't discuss just cause provisions at all in your direct testimony, correct?
Correct.
And you are aware that Chief Swanson has a contract with the Woodstock, Village of Woodstock for just cause, that includes just cause provisions for his removal, correct?
Yes, ma'am.
And are you familiar with the New Hampshire law for just cause for police officers?
I'm just gonna object. You said New Hampshire, you might have meant
Oh, I'm
Vermont.
sorry.
Vermont.
My New Hampshire roots are showing. Are you familiar with the Vermont standards for just cause for police officers?
I think there was something in the record, but I couldn't recite them to you, but it made clear that, there had to be cause and it had some specificity. My testimony is related to what reasonably a police chief is expected to do and how to perform, and whether or not those expectations were consistent with what are generally accepted practices and standards.
So you never made a determination as to whether Chief Swanson's behavior rose to a level of just cause for termination. That wasn't your responsibility, correct?
Correct. That's for the finder of fact, either the board or the courts, which is the role of the expert is just to explain what those standards are, and then the reviewing authority can determine whether or not that conduct rises to the level that would support a particular disciplinary or sanction.
You didn't make any determination that any charge against Chief Swanson rose to the level of egregious behavior, did you?
I just explained in my testimony the seriousness of certain responsibilities and how they were contrary to accepted standards. Yes, ma'am.
But you didn't describe them as egregious in any form. You can't hear me?
Now I can. Yeah, if you start off, can you hear me? That kind of, I think, activates whatever it is we're activating.
I could do that, it'll probably annoy everyone in the room.
Go ahead.
It's okay.
So, can you hear me?
Yes. Okay, now I can.
Okay. You can describe any activity on the part of Chief Swanson as egregious, correct?
No, I didn't attach a value. I explained what the standard is in my experience in training, having been involved in policing for 50 years and 32 as a chief and a trainer.
And you talked about this preponderance of the evidence standard in your direct. Can you hear me? Okay. You talked about this preponderance of the evidence standard in your direct, correct?
Right, that's what I would look at as an administrator for, whether or not discipline was warranted.
And that has nothing to do with the just cause standard that we're talking about. That's a different kind of analysis.
I don't know if that is or not. That would have to be instructed by the hearing officers what the standard is in the analysis.
You aren't familiar with the fact that just cause in New Hampshire, here I am again, just cause in Vermont requires prior notice of allegations, correct?
We're just gonna.
If that's what you represent, I wouldn't, debate that with you, no.
Let's hear the objection.
My objection is that Mr. Deckmar has been very clear about what he's been asked to testify about. He's not offering an opinion on the ultimate issue, which is for the trustees. This is a legal question, which he just said is for the hearing officer. And I think his testimony is clear on this. And I don't think it's appropriate to try to get a legal opinion from this witness who's not being proffered to offer a legal opinion.
So I do agree with the objection in that I didn't hear him make any, submit any opinion on the ultimate issue. You're asking about it, well, allow the question, but I don't see how it's part of his opinion.
You didn't make any opinion regarding prior notice, whether prior notice was given to Chief Swanson of any allegations, correct?
I noted in the record that there was notice given by the city manager, and then an opportunity to respond to those. I don't know if that satisfies what you're asking me, but I did note that was in the record.
Okay, let's talk, can you hear me?
Now, go ahead.
Let's talk a little bit about that issue. Is it your opinion that it's fair and reasonable for officers to be given some type of notice if they are violating a policy?
It depends on the policy in terms of, what you mean by notice. Do you mean corrective action such as verbal counseling or some sort of documentation and a written reprimand or a suspension is going to depend on what your assignment is, whether or not reasonably you should have known, and that you make a decision just not to do it as opposed to you didn't know you should have done it. And so all of those factors have to be weighed before you determine whether or not a certain sort of discipline or corrective action is taken. It's not just simply everybody gets a free bite at the apple. It depends on were you trained, have you historically done it? Okay, you just chose not to do it.
Can you hear me?
Good, now I can.
Okay. You didn't see any evidence of any kind of notice given to, or opportunity given to Chief Swanson to cure any of the issues that were made against him, correct?
I did not see in the record prior to the, for lack of a better term, lateral notice, pre-discipline. I didn't see anything in the record prior to that, no ma'am.
And so you did not make any determination whether that was fair and reasonable for Chief Swanson in this situation?
One more time.
You didn't make any determination in this case whether it was fair or reasonable for Chief Swanson not to have been given any notice of his alleged violations, correct?
I found most of these were pretty elementary that you would expect from someone in a police chief's position, as opposed to say, it had been, he submitted his first budget and there was issues. I would expect that to be corrected because it's his first budget perhaps. Something that he's unfamiliar with, but those things that, as a sergeant, I believe he was a sergeant before or a corporal, those are all tasks that are charged with some sort of supervisory responsibility. And then the actions that I saw were fairly basic. I don't think they required, coaching. And to me, it was more of an accountability issue, frankly.
But you didn't make any determination that the types of things, oh, I'm sorry. Can you hear me?
Yes, okay.
Okay. You didn't make any determination that the types of things that you're referring to, the policy violations, that those rose to any serious level, correct?
Well, if you look at the record in total, it significantly impacted the agency, where you have individuals that have said that if the chief is returned to that position, they would quit. So to me, that raises significant concerns. Now, does that mean necessarily that's going to happen? I don't know. But if the environment in which those employees are operating are toxic, that so toxic as they're characterizing it, that they're going to quit, that's a serious issue. That's how I got the fire department, is because of the lack of leadership in the toxic environment, and they just needed somebody new to come in order to address all that.
But you didn't evaluate that based on, can you hear me?
Yes, ma'am.
You didn't evaluate that based on just cause standards. You evaluated that on the standards of whether or not this was something that was good or bad for the police department.
I think this has been
Just
I think this has been covered by my previous objections. This is not an opinion. He's not offering an opinion on this cause. And continuing to, the point has been made. This is also beyond the scope of, am I
Counsel?
correct?
Just cause is the heart of this case. And this expert has been paraded here to offer opinions, and if it has nothing to do with just cause, why would he be here? So if he's just offering opinions about the appropriateness of various hearsay evidence or other things that are alleged, I don't see what the relevance is if I'm not allowed to question him.
He's offering opinions about accepted standards of conduct, about reasonable standards of conduct for law enforcement agency heads. He's testified that Mr. Swanson's conduct did not meet accepted standards, and that the ultimate issue was for the fact finder, in this case the trustees, and the in their findings of fact and conclusions of law to decide the ultimate issue. He's not opining on the ultimate issue because it involves a legal question. He is not a lawyer. The application of the law to the facts is for the trustees alone. And that is why his opinion is relevant. It's rebutting Mr. Mello's opinion regarding deviation from or acceptance of standards, and the ultimate issue is for the trustees.
We're comparing apples and oranges here. Richard Mello testified that there was nothing that would reasonably lead to the termination under Vermont law. He incorporated his understanding of reasonableness, prior notice, his understanding of just cause. That's an entirely different situation than what we're dealing with. So we have apples and oranges.
And I just want to say, I had an objection to that he should not be permitted to provide a legal question on the ultimate issue. I understand the trustees accepted his affidavit anyways, but I think that's improper because he is not a lawyer. He's not an expert in Vermont law, or in any, or contract or 1931 or 1932. And it's improper for him to provide an opinion on law, just like it would be improper for Mr. Deckmar to provide an opinion of law.
So I will allow this question, but I only heard in this witness's testimony that he was providing an opinion on sort of the technical issues surrounding policing and the issues that were underlying the just cause determination. But I can agree with counsel that the just cause determination is ultimately a mixed question of fact and law that I think is for the trustees to find and is not for any witness to opine on. So I'll allow the question, but I think we're at the end of that line of questioning.
Yes, but this is cross-examination, and I'm allowed to probe this witness in terms of his overall credibility around the opinions if he didn't consider the basic issues that are at play here.
Well, let's hear your further questions, but as to this question, I'll allow it.
Do you remember my question?
No, I apologize, I do not.
Neither do I. Let me see if I can get back to where I was. Okay,
And ma'am, if you would, if there's an objection, if you'll just hold up your hand, because thank you.
I'll try. Okay. So the administrative violations that you have, I know, where I missed, I'm sorry. I asked you if all of the various things that you didn't evaluate, you didn't determine, and I think we can move on after this, but I just want to clarify. The things.
Hello, it's frozen.
Frozen.
Okay, go ahead.
Okay. My last question, I believe, was that the things that you identified as policy issues or administrative, I think violations, you said, those types of things, you did not, in fact, make a determination that these rose to the level of just cause.
No, that would be for the trier of fact.
Okay. And you did not make any determination as to whether there were any issues around notice, prior notice, that should have been adhered to that were not.
I'm sorry, could you repeat that for me, please?
Yes, you did not make any determination as to whether Chief Swanson was entitled to prior notice under Vermont law.
Under Vermont law, that's correct.
Okay. And, okay. Did you look at Chief Swanson's performance evaluation in June of 2024?
I did. That was admitted, I believe, as part of the record.
And did you see that he received an excellent performance evaluation?
Yes.
Okay. In forming your opinions as to what was violated by Chief Swanson, you accepted various things as true, correct? Oh, he's frozen. He's frozen.
Hello? Okay. Go ahead.
Can you hear me now?
Yes, yes.
Okay. In making your determination regarding various policy issues or administrative violations, that type of thing, you accepted certain facts as true.
I accepted what was reflected in the record in the sworn testimony that was cross-examined, yes.
Okay. And when you read the testimony, one of the things you read was, in the transcript, was that Chief Swanson did not attend traffic court on the one occasion that he was scheduled to go to court, correct?
Yes, ma'am.
You accepted that as true.
Yes.
You accepted that Chief Swanson signed off on some type of force training for Sergeant O'Keefe, that Chief Swanson signed off for some type of force training for Sergeant O'Keefe that did not include the proper amount of training, correct?
Yes. All those things that were subject to sworn testimony and cross-examination, yes.
You accepted that Chief Swanson somehow had allowed untrained officers to be in the field? Was that something you accepted?
That's what was in the record, that they have tiered officer certifications, and if you have a certain certification, you require enhanced supervision, and the record reflected that those individuals were scheduled without supervision.
Did you see any evidence that Chief Swanson allowed, excuse me, did you see any evidence that Chief Swanson allowed untrained officers in the field?
Just what was testified to, or findings in the trustees' findings.
If, in fact, Chief Swanson's officers were all fully trained under Vermont law, as the law requires, does that change your opinion as to whether there was any issue with that?
Right, if everybody was trained and that training is reflected in the documents, then of course that would not be a consideration.
And have you reviewed Chief Swanson's affidavit in which he does indicate that he has never allowed an untrained officer to be unsupervised in the field? Did you review that?
I did.
And did you just discount that?
I relied on the testimony in the record.
So you did not
In the
take...
finding,
Okay.
I'm sorry, ma'am.
I interrupted you, I'm sorry, go ahead.
No. Based on the information in the record, I considered that a violation or something that would be contrary to accepted practice.
My question was, you didn't take into account Chief Swanson's denials in his affidavit of some of these issues when you were forming your opinions, correct?
Well, when I weighed it in totality of all the facts, which was there was times where the schedule, according to the record, there was folks that weren't properly scheduled. So based on testimony in the record reflecting some of those folks who were in there, it was possible that those individuals were placed in those positions and the chief didn't know about it because their schedule wasn't done. But that doesn't omit the responsibility that the chief has to ensure that the schedule is done. So he very well could place in the affidavit that, he did not knowingly, but his responsibility, he doesn't believe his responsibility by delegating a task to others. That responsibility continues to rest with him, and he has an obligation to monitor those tasks to ensure that they're done.
Do you know if anyone required supervision in the, oh, can you hear me? Can you hear me?
Now I can.
Do you know if any officer required supervision in the Woodstock Police Department, or whether they were non-provisional certified officers?
Just what was in the record.
So you are speculating that he may have delegated some duty to somebody else to allow unsupervised officers in the field?
No, what I'm saying is there was controversy around whether or not there was a schedule, and some folks did not know when they were working. And so if that occurs, then, and others indicate that folks that should have been working with a supervisor didn't, looking at the facts in total, then that's not inconsistent with what the record reflected.
Well, wait, I think we're talking about two different things here. Let me see if I can clarify. Can you hear me?
Yes, ma'am.
Okay. So my question was, you discounted or didn't accept Chief Swanson's testimony that, one, there was no officers that were not certified properly, and two, he never allowed any uncertified officers to work unsupervised. So you're discounting that, basically. Am I correct?
I don't know if I'd characterize it as discounting. I found more weight in the record that was reflected that folks that were not appropriately certified did work.
Who wasn't appropriately certified?
Yeah, that the appropriate certifications allow them to work without supervision.
Who was this alleged officer that was uncertified?
I don't recall the name.
What evidence was there
It was-
that this happened?
It was, I believe, reflected in the findings.
You're talking about the findings of the trustees.
Yes.
Okay, but you didn't see anything other than that to support this allegation, is that correct?
No, I believe that there was also testimony to that effect, or it was in the record. There was something more than just the findings.
You don't
I think the
recall,
record is, I'm sorry.
you don't recall what that might have been, who that might have been, or on what circumstances, under what days, anything like that?
I don't recall those.
You had some testimony about police officers needing to wear uniforms at all times. That obviously has some exceptions, correct?
Absolutely.
And that includes sometimes plainclothes officers, correct?
Undercover, yes.
And they're allowed to make custodial arrests, correct?
Yes, under certain circumstances, sure.
And were you aware, when you were reviewing the issue of the, oh, I'm sorry.
Go ahead.
Can you
I
hear
can
me
hear you.
now? Okay.
Yes.
When you were reviewing the issue of the videos that was shared by Chief Swanson, you reviewed that issue, correct?
Yes.
And did you, when you did that, did you take into consideration that Chief Swanson was sharing these videos in a context of obtaining legal consultation?
That's what was represented, part of that, yes, is in the record.
You certainly agree that information can be shared for legal consultation on occasion, correct?
If it's an individual that's authorized,
Well, isn't
I think what you want, I'm sorry,
isn't the ultimate authority to authorize that with the chief?
no, as a leader or agency head, you've got to be particularly sensitive if you're involving a family member in agency business, because there could be the perception of a conflict or bias. And so you would want, if you're going to seek legal opinion, you would want someone that would offer an unbiased and not be subject to an allegation of a conflict of interest.
And is that something that is reflected in any kind of police department policy?
Yes, I think it's in the duty conduct policy, officer conduct policy. Talks about not disseminating confidential, that consider the information confidential, and it included records, reports, technology, that sort of thing.
I'm talking about, can you hear me? I'm sorry. Can you?
Not good, now you can.
I'm talking about your idea that somehow legal information cannot be shared with a family member if it's for legal purposes. Is there any policy, Woodstock Police Department policy that you're aware of that makes that distinction?
Well, the distinction would be that, this is a family member. They're not contracted with the city for this particular issue. And you just don't bring reports and recordings at home and share them. I mean, that's kind of basic. And you certainly don't involve family members in issues that may have legal implications because of the allegation of bias or conflict.
Okay, well, first of all, let's back up a little. You said,
I'm sorry?
okay, I have some questions about that, what you just said. So you just said that he took some files home with him? Is that your understanding?
Some what?
Confidential files home with him, is that?
No, I said you don't take files or reports or recordings home
There's no
and share them with family members.
There's no allegation that Chief Swanson took anything home, is there?
Or access. I mean, he accessed the information. I think that's why in there it says technology, because through technology you can access.
My original question was, there's nothing in the Woodstock Police Department policy that says specifically that if you're going to get legal consultation, you can't do it with your spouse, especially informally.
I think that is inferred in the conduct policy. I mean, it seems like it would be pretty clear.
I need to get one more thing on the end of your questioning.
That's
I'm sorry, ma'am?
I'll be right back.
Yes.
I'm back. Can you hear me?
Yes, ma'am.
Okay. You said you reviewed the opinions of Richard Mello?
Yes.
Okay. And do you agree that there are best practices for investigations?
Yes.
You saw Mr. Mello's critique of the investigation that was conducted in this case, correct?
Correct.
Let me ask you also, in terms of the sharing of the videos, you read Chief Litchley's affidavit? Former Chief?
Yes.
And you were aware that Chief Litch indicated that he had done similar, he had shared similar evidence in similar ways for legal consultation as Chief Swanson?
With his family?
I'm saying he had shared similar things with Chief Swanson.
I'm sorry, who?
Former Chief Litch had indicated that he had shared similar types of issues with Attorney Sullivan, correct?
Yes.
So let me make it clear. Your major problem with this is that it was Chief Swanson's husband that he shared issues with?
It's a family member, correct?
His husband, not just a family member, right? His husband.
Right.
And
Yes.
that was you had a problem with that.
Yes.
Okay.
I'm going to object. The testimony is not that he had a problem because it's his husband. He had a problem because with any family member. And I can't let the
Yes.
record reflect that it is in any way related to the sex or gender of his spouse.
He just said,
Noted for the record, I mean, he did say any family member.
right, and then he said he had a problem because it was Chief Swanson's husband, both of them.
I'll ask a follow-up question.
Okay.
Okay. You saw Mr. Mello's conclusion that Mr. Duffy did not follow conventional best practice methodology in conducting an investigation, correct?
Correct.
Did you ever review the Woodstock Police Department internal affairs policy?
I did.
And you're aware that Manager Duffy did not utilize this internal affairs policy when he initiated an investigation into Chief Swanson, correct?
There was deviation, yes.
Right, and those deviations were significant, correct?
I don't know if they were significant to the finding. I've looked at a lot of different IAs, and that's why I focused on what the trends and patterns that were identified that the village manager acted on, and then the record that was subject to sworn testimony and cross-examination. So I didn't put a lot of emphasis, I didn't put really any emphasis on the investigation. I looked at the record where folks were subject to cross-examination that resulted in the findings.
So you didn't go beyond that to evaluate, can you hear me?
Yep, good.
You didn't go beyond that to evaluate whether or not the deviations in the internal affairs policy were significant for the application of justice to Chief Swanson, correct?
My review looked at whether or not there were sufficient patterns that caused the village manager to act, and then when he did act, how discerning was he in evaluating the report and then doing the notice that resulted in the pre-disciplinary hearing.
So you didn't start at the beginning with the internal affairs policy to determine that that it was not used and that was a significant deviation?
You'd have to read the areas that you think are significant for me to ask, or for me to respond.
Pause right there. The board wants to take a 5-minute break.
Okay.
So Mr. Deckmart, we're going to pause. If you want to turn off your camera, whatever you can, we'll be back in 5 minutes.
Thank you.
Thank you.
Okay, I think we're almost done with the video. Can you hear me right now?
Yes, ma'am.
Okay, I think we're almost done with the video thing, but I just wanted to clarify that there was no issue for you with Chief Blish, former Chief Blish, sharing the videos, sharing evidence for legal consultation with the second in command's husband at the time.
Right. He wasn't a family member, correct?
He was just the spouse of the second in command, and that was fine.
He wasn't a family member of the chief. He wasn't the spouse of the chief.
Okay.
I'm a little confused. So when Chief Blish was okay with this, because Chief Blish was not related to Joe or Nico, it was okay for him to give his approval. Is that what you're asking?
That's what,
No, I'm asking, is that what you are asking?
yes.
Okay, I got it. Thank you.
So it's, somebody just asked for clarification, so I'm just going to clarify with you that you indicated that it was fine for former Chief Blish to consult with Attorney Sheldon, who was the spouse of his second in command at the police department, but not for Chief Swanson to consult with his husband.
My understanding is I thought there was something in there where he had previously been contracted with the city to do that stuff. So I presume that he was contracted with the city to do that. But it was clear in the record that in this instance he was not.
I want to just clarify a couple of things also. You said that with regard to the issue of the uncertified police officers, that there was some evidence in the record that they were uncertified and they were somehow acting in ways that they were not supposed to, correct?
I think the record said they had been scheduled without adequate supervision.
Okay, I want to read you some testimony. This is at page 196. There was a question of Sergeant O'Keefe. When you first got to Woodstock Police Department, did you make any observations about the training level of the junior officers that were there in the department? He says, yes. And that question was, can you tell us what you ascertained? He says, it was uncomfortable. We had people, 2 folks in particular, who hadn't had any police academy training. They're level 2 certified, which basically means you can go to school for 2 weeks and be a cop. You're not a full-time certified, but you are allowed to work as a police officer. We had 2 folks, we had 2 folks in particular working regular shifts with minimal to no supervision, working in that capacity. Okay, are you saying that that's what you rely on?
Yes, that was part of that in the finding, yes.
Okay, so when Chief Swanson clarified in his affidavit that these officers were fully certified under Vermont law to be in the field, you're somehow disagreeing with that?
I didn't see in the record their certifications.
But you saw in the record Chief Swanson's affidavit about the fact that these officers were fully certified and they were cleared to be working, correct?
I'm sorry?
I didn't say anything.
Okay. Yeah, based on the testimony of O'Keefe.
What does that mean, based on the testimony of O'Keefe?
What you had just read to me, where he had indicated that there were folks on there that weren't certified.
Okay, so you accepted Sergeant O'Keefe's statement, you're not full-time certified, but you're allowed to work as a police officer. He said that was the Vermont law. You're saying that Chief Swanson somehow disobeyed the law?
No, I'm saying that O'Keefe indicated that they had been working with nil or minimal supervision. That was required.
And Chief Swanson said that wasn't true, and you accepted Sergeant O'Keefe's words on this, correct?
Correct.
Okay, just wanted to clarify that to make sure everybody understood. But the other thing is, you are not relying on the fact that they all the certified officers had the legal amount of certification required to work as they were directed.
There was different levels of certification for everyone in the department. I don't think that was an issue, correct?
And you don't have any evidence that they were allowed to work outside of their certification.
Other than the testimony of O'Keefe.
Okay. All right. Oh, I also have to correct something. I heard you wrong, and I apologize. When I was talking about parliamentary, I thought you said parliamentary. You really said paramilitary, correct?
Oh.
I'm sorry. It was very silly.
That's okay.
But you said there was a parliamentary process that applies to the police process? Paramilitary process? Can you-
Yes, almost every police department is configured as a paramilitary organization with a strict adherence from a long history of culture of chain of command and not going above the chain of command. And so that, the downside to that is there is not only a reluctance, but creates a very difficult barrier to get complaints pushed up, which is why police chiefs, department heads, city managers, it's called management by walking around, where you bump around and you ask folks how things are going. And then you're hopeful that in those encounters, if there's issues, you'll hear about them. Another way is, it's called the 360 evaluation, where everybody in the agency anonymously gets to evaluate individuals in their chain of command. And then you use that as feedback to help, guide you on what issues are important to the employees. But you're always looking for, I'm sorry.
Vermont, the Woodstock Police Department was not, in fact, a parliamentary police department, correct?
Paramilitary?
Paramilitary.
Paramilitary.
Okay, paramilitary. It was not, in fact, a paramilitary department, correct?
It reflected a paramilitary when you have a rank structure and you have a chain of command. That's reflective of a paramilitary organization.
Isn't paramilitary usually associated with things like ICE? That's a paramilitary?
No.
Okay.
No. Paramilitary means if you look at the management model of the agency, are there requirements that are placed upon employees in terms of how they operate inside that agency, in terms of chain of command, officer in charge, the police chief. All of those are different sets of positions that are tiered that create what's known as a paramilitary organization.
So-
Now, it's not ICE. Well, ICE is paramilitary also.
Oh, it is. So I wasn't wrong about that. ICE is paramilitary.
Sure. Yeah, every law enforcement agency I've ever seen has a paramilitary model.
And you're claiming that Woodstock is also paramilitary? The Woodstock Police Department is also paramilitary?
Yeah, if you look at its rank structure and the way that their policies are generated, in the manner in which those policies point to rank for responsibility, yes.
Okay, and I hate to jump around, but I need to go back to one issue just to make sure it's absolutely clear. I read you the statement that Sergeant O'Keefe testified. We had two folks in particular working regular shifts with minimal to no supervision working in that capacity. Remember we talked about the two full-time level 2 certified officers?
Yes, ma'am.
Okay, because this is a serious issue, I just want to make it, I want to get this absolutely clear on the record, that there is no evidence that you have heard that even that statement, that they were working with minimal to no supervision in that capacity, there's no evidence that they were working outside of their legal certification when they were working for Chief Swanson.
That was not clear in the record, yes, that's correct.
Okay, so there's no evidence to support an allegation that Chief Swanson allowed uncertified or poorly certified officers to work in a manner that did not meet legal requirements.
Well, ultimately, the credibility of those statements are going to be weighed by the trustees. What O'Keefe said is they were working with minimal or no supervision. It wasn't explored with, okay, what does that mean? And so I would expect that, there would have to be, you would expect that there'd be schedules and that sort of thing that would show where people are working, whether or not there's adequate supervision. But according to O'Keefe, who's intimately involved in the operation of the police department, he made that statement.
And you did not do that research or that investigation to find out if, in fact, anyone was allowed to work in a way that did not meet legal requirements in Vermont, correct?
I did no independent investigation. I relied on the record.
Okay, thank you. Now I want to get back to Mr. Mello's report. And just what another issue, that's easily verifiable, right, in terms of what the requirements are for level 2 certified officers? Something you could easily research? Okay. And getting back to Mr. Mello's report, you saw Mr. Mello had an issue with the fact that in the investigation, allegations were accepted without any objective findings of the evidence underlying those. The testimony was accepted as true without any documentation. You understand that, correct?
Yeah, there were some of those in there, yes.
Yeah, and you agree that that's not the best practice when you're disciplining an officer to rely only on what somebody else says about that person, correct?
It depends on, how many folks you interview, whether or not that allegation would be sustained or unsubstantiated or founded. And so you would expect that each one of those allegations would have evidence or finding to support whatever conclusion there is, yes.
You would in fact expect that, right? You would expect that?
Yes.
Okay.
And if there wasn't, then I would, as the person that is weighing the report, the one that's considering discipline, then I would make a decision as to whether or not there was evidence in the record that supported that allegation and whether or not to include it in the discipline.
You agree with Mr. Mello's statement that simply really listing an allegation several times in a document under multiple policies does not increase or compound the seriousness of an allegation, correct?
Yes, you would need evidence to support those.
So you're not in disagreement with Mr. Mello when he says allegations must be substantiated by facts and evidence, correct?
No, that's foundational for internal affairs, yes.
And did you also see that Mr. Mello concluded that Mr. Duffy relied heavily on rumors, third-hand information, unattributed statements, and personal opinions? Did you see that?
I did, which is why my focus was on the record of the testimony that was presented to the trustees and which you, of course, had the opportunity to cross-examine. Yes, ma'am.
But you didn't see any objective evidence other than testimony to support the facts that were alleged against Chief Swanson?
Well, testimony is evidence.
Well, that's allegations, correct? People coming and saying something happened that doesn't show any of the underlying evidence, correct, for those allegations?
I didn't see any other underlying evidence. I guess I'm confused.
Okay.
In cases all the time. I'm sorry.
I think you've answered it. You just relied on the testimony, right?
Correct. The record, yes, ma'am.
Okay. You saw Mr. Mello's opinions about the no confidence vote that was taken. Do you agree that no confidence votes are extremely subjective and can be based on internal policies and popularity contests?
I would not disagree with that.
Okay. Would you also agree that relying on a subjective no confidence vote is not a common nor best practice and should only be used to inform a potential investigation?
I think that's one of a number of elements that you weigh, but I wouldn't put any greater weight on it than anything else. And depending upon what issues were identified, it's not unusual for police chiefs to have to deal with that issue.
And you agree that in itself, it's not sufficient? Can you hear me? I'm sorry.
Yes, yeah, it's not sufficient, in my opinion, standing alone.
Okay. And we touched briefly on the internal affairs policy. And I just want to ask you, in an internal affairs policy, generally, and in the Woodstock Police Department policy, there's a form or a process that indicates that the misconduct has to be detailed, the findings have to be set forth, the facts of the investigation have to be set forth, and a conclusion has to be set forth, correct?
Yes.
And then the report, according to this form, it's signed under penalties of perjury, correct?
Yes, and that's, that form has been recommended by the Department of Justice since, I think, 2004 to eliminate that because it causes folks to be reluctant about filing a complaint, and police departments want to welcome complaints because otherwise they go to somebody else and the police department doesn't have an opportunity to investigate those until after allegations are made and media coverage occurs. So you don't want anything that's going to deter a complaint, and that's been identified as something that does. So that would be contrary to best policy.
You're saying this internal affairs policy is no longer in effect?
I'm saying, no, it's obviously in effect. That's up to them what they want to do. I'm just saying that best practice is you don't threaten people with prosecution when they make a complaint against, and that's not me, that's what the DOJ came out with in, I think, 2004, 2005.
Have you seen anything in this internal affairs policy that threatens people with prosecution?
That's what you just read to me. You citing under threat of perjury.
If they sign, if the investigator signs the report, are you saying they no longer have to? That's your issue?
No, I thought you read the complaint that people have to sign a complaint, and there's a warning on there that says that you're subject to perjury.
No, I'm saying when the person who does the internal affairs investigation completes that investigation with policy violations, allegations, facts, and conclusions, that person then signs their findings under perjury, under penalty of perjury. You said you reviewed.
So you're saying that's the report, whoever's doing the investigation,
Yes,
they sign it.
yes.
Well, that's with any police report. You can't falsify a police report. That's not unique to internal affairs.
Okay, so that's best practice to have somebody sign it.
Yeah, whoever's doing the investigation should sign the report because they're the ones that are responsible for the findings. Yes, ma'am.
Okay, thank you.
I just, if you're moving,
Oh, I'm sorry, did you have?
if you're moving on from this topic, I will.
I am.
Okay.
Okay. Have you ever dealt with allegations against a gay police officer, Mr. Decker?
Sure.
Pardon me?
Yes.
How
Yes.
many times?
I have a number of officers. I really don't pay attention to that in terms of how disciplined is. So I'm not like I keep score. So I can just say that, yeah, I mean, discipline is based on, conduct, not what your status or your living arrangement is.
Just
But
ask.
I would say easily, incidents, at least a dozen or more.
And have you ever found any of those investigations motivated by bias?
I can't hear you, ma'am.
Have you ever found any of those investigations motivated by bias?
The allegation being motivated by that or the investigation being biased?
No, the allegation of being motivated by bias on the basis of sexual orientation.
No, not for an internal investigation.
Are you aware of any gay police chiefs in Georgia?
Yes,
How many?
I have no idea. I know I have a number of colleagues that are gay or lesbian. Half a dozen, 10, 12, I don't know. We have 550 some police chiefs. I don't really tend to focus on their living arrangements unless it becomes evident. I know on the commission, I served with them, and IACP, I served with them.
And in the dozen or more that you dealt with, that it did involve, none of those were anything that you found any bias issues involved in, correct?
I don't understand the relevance of this question.
What's the proffer?
Relevancy is based on the fact that his experience and knowledge dealing with gay police chiefs, and whether that has ever come up before in his experience, or whether he's dealt with it.
We already said yes.
Right, now I'm asking him, in those situations, the fact that this issue of bias was never addressed is relevant.
I will allow it, but I think it's outside the scope of his report, and the best way to get this evidence is with your witness, who I don't believe opined on this issue at all. So it's difficult to see why it's necessary to ask it of this witness.
Okay, you know what, I don't really need, I'll withdraw it. I'm
Okay.
done. Thanks.
Okay, thank you.
Thank you, ma'am.
Thank you.
Hold on, Mr. Deckmar.
Just a few follow-up questions for you. Can you see and hear me okay?
Yes,
I think I heard you say earlier, testimony is evidence.
yes,
Is it accepted in a variety of fact-finding settings?
yes. In my experience in hearings and deposition in criminal court, civil court, that's part of the evidence that's presented in court. Many instances, it's the only evidence.
And do you consider it reasonable to rely on testimony as evidence when it is sworn and subject to cross-examination?
Yes, I find that to be more reliable than information that is just contained in a report, yes.
Is it a problem if a chief offered to credit someone with a 4-hour use of force training without completing the 4 hours, whether or not the trainee actually accepted that offer?
Yes, that would be a problem. Training standards and documentation of training is a fundamental responsibility of the agency head. And it's imperative that those be accurate because they call into question the integrity of the agency, not only as it relates to the training records, but then more broadly, what other integrity issues might there be. So training records have got to be very accurate.
So the offer to, give a pass on the training, even if the person ultimately did the training, just the offer to, fudge the numbers would still be a problem.
Yes, that would be contrary to accepted standards and it would be a significant issue.
Did you review Mr. Swanson's testimony at the first hearing?
I did,
Did you consider it in forming your opinions?
yes.
I want to clear something up. Earlier, and it may have just been the way the questions were worded, but did Attorney Frass ask you if you had reviewed Joe Swanson's affidavit? I believe what she was referring to was a 100-paragraph affidavit provided on Friday afternoon of this week. Is that something you ever reviewed?
No, I thought it was some of the responses in the notice, his response for the discipline. No, I've not seen that.
Okay. You haven't reviewed Mr. Swanson's 100-plus paragraph affidavit from Friday afternoon?
No.
Have you seen an affidavit from Mr. Blish or former Chief Blish from this Friday afternoon?
No, I don't believe so. I think what I saw about Mr. Swanson's spouse being used, that he had been contracted previously for the city.
Okay.
And so I believe that was when the chief, when she referred to Chief Bliss, then that would have been the circumstances under which he would have been involved.
Earlier, you testified about the problem with sharing information with a family member. Do you recall that?
Correct.
Was the problem with sharing, with Mr. Swanson sharing information with his family member in any way related to the fact that his spouse is male?
No, as a family member, any family member.
Would your opinion be any different if his spouse were female?
No.
Would your opinion be any different if he shared the videos he shared without a formal attorney-client privilege, legal engagement with a parent,
No.
with a child?
No, none of those are appropriate. You don't take police business and share it with family members, like it's some sort of spectator sport. I mean, you have an obligation to keep that information confidential for a couple of reasons. One is the legal implications, and two, if it ever gets around, people are, like gossiping, talking about it, it undermines the confidence the public has in you. And if the public doesn't have confidence in the agency and the people, they're less apt to engage as witnesses, file a complaint, report a crime. So the notion that you can authorize the dissemination of information to a family member, be it a spouse or a child, is, in my opinion, contrary to accepted practices, and certainly one that I'm not familiar with chiefs engaging in.
Do you think Mr. Duffy, the village manager's decision to demote or to recommend that the trustees demote Mr. Swanson was motivated by bias based on Mr. Swanson's sexual orientation?
Objection. She's already said he didn't investigate that at all.
Attorney Frass made an implication about the motivations of, male, about, LGBT police chiefs and how they should, what his prior experience was. I think it's appropriate to ask about bias in light of her cross-examination.
I didn't ask him anything about whether he had made that opinion at all, and neither did Attorney.
I thought the door was open on cross because you asked about whether it was appropriate to have shared this information because of the fact that it was a husband. So I thought that opened the door. So the objection's overruled.
Okay. Do you have my question in mind?
Yes, it would seem that unless that marriage was recent and he, the city manager or village manager was unaware, there's no indication in the record that when he was appointed that his marital status or his orientation was an issue. I didn't see that in the record.
Thank you. No further questions. Brief request. Okay.
Yes.
Don't go anywhere. One more.
No, I'm not, no, yeah.
Yes, hello again, briefly.
Yes,
Can you hear me?
yes. Yes, for whatever reason, whatever y'all have done is working. No, stay closer, I think that's the deal, is it's,
Oh, okay,
yeah, I'm not getting any, no interruptions.
okay. So I guess there was a misunderstanding during my questioning of you when I asked you if you had reviewed the affidavit of Joseph Swanson and former Chief Glitch. So let's just clarify that. You were not provided the affidavit of Chief Swanson.
Yeah, I thought you were referring to the record where they had the responses and he had his attorney, there at that. So I'm sorry, I apologize, I wasn't clear on that.
That's okay, we're just clarifying it now. You were not provided with that affidavit.
That's correct, ma'am.
You were not asked to render any opinions or to see if it changed your opinions if you read that affidavit.
Correct.
So you had to rely on the information that you had from the hearing and not any of the responses that Chief Swanson provided in explanation or justification or exculpatory evidence that he provided in his affidavit, correct?
Correct. I relied on his testimony in the record, but there was, and the response with him and his attorney.
There was no reason between Friday evening and now that you would not have been able to review that affidavit, correct?
Objection. I presented numerous evidentiary objections to the affidavits that I do not believe the trustee should consider. They were admitted over my objection. I'm not going to share evidence I objected to with an expert who's offering opinions.
Okay, fair enough. I'll allow the question.
My question was, there would be no reason, you didn't have any physical limitations or any other limitations that you could not have reviewed those affidavits between Friday evening and today, correct?
No, I did the bulk of my work this weekend because I got such late notice on this, so I was engaged midweek, so I could have reviewed it, I believe.
Okay. And therefore, everything you relied on was simply what the other side wanted, what Manager Duffy's team decided that you should review, correct?
I had, I think, 900 or 1,100 pages of record that included, I believe, all the testimony. But yes, it was provided by the folks representing the city.
Okay. And do you have any evidence whatsoever? Oh, you keep calling the city. Do you know how big Woodstock is? Do you know what the population is?
I'm sorry, is it what, about 2,500?
Okay. Just wanted to clarify. Now
Yeah,
you're,
well, we call them, we don't have the distinction between villages and towns and cities. We're used to just call them cities, regardless of their size. I'm sorry.
is there any evidence, you talked about leaking information or attorney-client privilege being violated. You don't have any information whatsoever that ever occurred in this case, that Attorney Sullivan ever provided or disclosed confidential client communications with anyone, do you?
No, the issue had to do with the nature of the relationship, not whether or not it was disclosed after that information was shared.
Okay. Thank you.
I have no
Thank
further
you.
questions either.
Okay.
I'll just-
Just send them off.
Thanks so much for your time today. You are free to exit the Zoom.
All righty, thank you all.
Thank you. No further witnesses.
Okay, so each party's case is closed. Would you like, maybe we should just take a brief break and you could have 5 minutes or actually whatever you want, but hopefully preferably short to make a closing.
Great.
Thank you. Okay, we're ready to hear closing arguments. was trying to noodle through the order. I mean, this case is very different than a standard civil action where plaintiff, defendant, and plaintiff gets to rebut. So I would entertain however you folks want to handle it.
Yeah, I have no preference, whatever, I'm happy to give Attorney Frost for preference.
No preference either, you may decide.
You can flip a coin.
How about we hear from you first? We'll hear from Attorney Hakes after. If you would like a rebuttal opportunity, we will grant that to you. So,
Pardon me?
if you would like a rebuttal opportunity to close, that's fine. So, please proceed.
Good afternoon. We're at the end of a grueling 2 days. I came here saying that I didn't expect anything different would happen as a result of these 2 days. That hasn't changed. I fully expect that you will dismiss everything I have to say. You will attribute it to client advocacy and just assume that I'm just doing a job here. But that's not the case. For me, this goes well beyond a job. This is about loyalty to the law and loyalty to justice and being on the right side of things. It is not simply a job. And when I talk about the law, it's because it is the law. I'm not trying to spin the law. I'm not trying to make it into something it's not. I'm not trying to bend it to fit the whims of my client. I am talking to you about the law because it is, in fact, what is controlling in this case. And it seems to be, it's not an area that reasonable people can disagree about. This is not a case with novel law concepts or things that are so complex that can't be understood. These are normal, ordinary principles of law. And it's not a case where there are two sides, and both sides are good people. That's not the case here. This is a case where there are lines. There are lines of right, and there are lines of wrong. And it's important to choose a side. And people who are choosing a side that is on the side of injustice are going to be on the wrong side of history, and they're going to be on the wrong side of the law when the appellate court gets to this case. So I remain perplexed because Attorney Hakes purports that she is acting in the best interest of the village, and to me, the best interest of the village would be following the law. And yet you are being informed about the law in ways, or advocacy is being done about the law in ways that are not in comportment with the law. The only remedy here that is in compliance with the law is reinstatement. I've given everybody numerous ways out of this dilemma. I've tried to protect the village. Chief Swanson has tried to protect the village. He has deep roots in this village. He cares deeply about this village. And I have tried from the beginning to give everybody a way out. Chief Swanson agreed to drop everything, and in the initial phases, if he were reinstated, as was required. I have informed everybody from the beginning that demotion was not legal, that this was not something that was going to be acceptable to the Superior Court, that it did not comport with the law, and my arguments fell on deaf ears. And I have tried to explain why this process does not comport with due process, why recusal was absolutely necessary under the law, why I do not believe any judge is going to find that this is an acceptable proceeding. But none of that seems to matter. Not the amount of money that is being spent in this process, not the reputation harm that is done to the village. None of that seems to matter. All that seems to matter in this case is somehow supporting the manager, not criticizing the manager, not evaluating the manager, not even looking into what the manager has done to lead you down this path. And most of all, as I said, demotion wasn't legal the first time, it's not legal this time. You cannot demote someone who has a contractual position. It makes no sense, it is not legal, there's plenty of precedent that says you cannot do that. But here we are again, and you're trying to do it again. But we can set that aside, because I understand, you can argue, well, it's a loophole, it doesn't matter if we demote him because it would be the same standard if we removed him. So you can argue a loophole. However, that's not going to work either, because there is no just cause. just cause is the standard that the Superior Court will apply to this case. And that standard is set forth in law. It is set forth in cases, it is set forth in many statutes, it is set forth in many places. And it is set forth in the contract in terms of that it is required. Just cause is required. You cannot get around that. You cannot say, oh, it means something different. It just means a minor violation of the policy. It means it's something other than what the law has said. The law has made it clear that what just cause requires is prior notice and egregious actions. And the reason it requires that is not some airy-fairy legal theory. It's because of fairness. The principles of fairness are what they go by. And this is objective and reasonableness. It's not based on the whims of a manager. It's not based on what people might think and feel about what the law should be. It's about what the law is. And you, as trustees, have already found that there is no just cause. Whether you realize it or not, you found there was no just cause in your first decision. When you said that he had no prior notice and there was no act warranting dismissal. The only way you could get around that is if you now change that opinion and say, well, we didn't know, so now that we know we have to find just cause, we are finding just cause, even though we didn't find it the second time, to try to get rid of this chief of police, this gay chief of police. And the only thing that is standing in your way is the law. And that is why this case will be appealed immediately when you make your decision. The egregious kinds of acts that warrant dismissal are well defined under the law. None of them exist here. They are things like theft, DUI, assault, sexual misconduct. You can read the law. This is not the kind of case where any chief of police deserves to be removed from his job. And as I said, these are objective, reasonable standards. They are not just because the manager says so. And the attempts, Manager Duffy is trying to avoid the law. He's like a lint collector. He's collecting all these little pieces of inconsequential things that he even admits would not rise to the level of dismissal. And he's putting them into one ball. He's collecting this and this from this, things that he even said he would have normally let go, but he's collecting them all retroactively, not even at the time, retroactively soliciting complaints, collecting them, putting every little piece of lint from all these different areas into a ball. And then he presents them to you as if, once he puts them all in a ball, as if they're a diamond. And he puts them in as if they were a diamond. Now they amount to something. Well, that's not the law. You can't just take a bunch of inconsequential or minor or things that don't rise to the level of just cause and say, well, a bunch of them now rise to just cause. It might sound reasonable maybe to some people or to a layperson, but it's not the law. It just isn't the way it works. And the other thing is all these little pieces of lint that Manager Duffy is collecting, those same pieces of lint, when they apply to other people, they just drift away. He doesn't collect them and put them into a ball. He just lets them go. They fly off into the wind. So the idea that the understanding the concept of just cause seems to be so foreign to Manager Duffy that he doesn't even understand that this is a concept. He didn't seem to understand the concept of fairness in his testimony. He doesn't seem to understand the idea of serious versus things that are not serious and that could easily be rectified. Just tell somebody what you want them to do. Tell Chief Swanson if you don't want him to do things. But no, retroactively, he wants to punish him. This is not about corrective action. It's about punishment. He wants to punish him. He didn't want to rectify the situation. He didn't want to make things better for the town. He just wanted to get rid of Chief Swanson. And that has been clear from the beginning, from the very beginning in terms of everything he has done. And it's interesting, he doesn't seem to understand the concept of just cause when it applies to Chief Swanson. He doesn't seem to understand prior notice, or he doesn't seem to understand things like egregiousness or seriousness. But when it comes to himself, in his own contract, he understands it because he contracted with you and he negotiated that he would have 30 days to rectify any of his poor performance issues. Anything that he did, he would need you to tell him 30 days in advance so he could have an opportunity to make it better before you terminated him for cause. He also put in his own contract that, oh, you can't just fire him for cause for anything. It has to be material. He put material, meaning serious, meaning something significant. So he protected himself in his own contract while clearly ignoring all of those principles when it came to Chief Swanson. In your opinion, you described Chief Swanson as conducting a fiefdom. That's the word you used, a fiefdom. Well, if we look at the facts in this case, the fiefdom was not Chief Swanson. It is Manager Duffy. He is the one who was acting as if this was his fiefdom. He is the one who had all of the problems. If you look at the employee letters from him that are in evidence, you can see people described him. They described his toxic work environment. They described his terrible management style. They described his retaliation. These are women. These are women who could probably bring lawsuits, but apparently they haven't. But these are women that he has treated poorly, he has treated badly, and they are no longer employees of the village. He believes his own style, his own judgment is superior to everybody's. It's superior to two chiefs of police. It's superior to everybody except himself. He even believes he's more superior than the court, that his judgment, he doesn't accept that the demotion was considered unlawful and reversed. He has told you that. He stands by it. He puts himself above the law. He's arrogant. He's hubris.
I just have to object to these personal attacks of Mr. Duffy. They're far beyond appropriate argument and they're offensive.
We're back to the manager cannot be criticized.
We're going to allow it, and the trustees will consider it in their decision-making. Carry on.
Okay. The evidence shows, which is what I would tell a jury, the evidence shows that Mr. Duffy is arrogant and hubristic. The evidence shows he has a corrosive management style. The evidence shows that he continues to believe and act as if he is the king of Woodstock. The evidence shows that he tries to speak for all of you, for the town of Woodstock. Even though the court overturned the unlawful demotion, he told the court that he found that, no, he didn't say he, we find the chief unfit. And he didn't call him the chief, obviously. He would never do that, even though he is, in fact, the chief. We find him unfit. So clearly, he is acting contrary to the interests of this village. And then we got to the issue of bias. And you hear, there's not a scrap of evidence about that. Well, if you come to that conclusion, you have to ignore a whole lot of things. You have to ignore the differential treatment. You have to ignore the fact that everything you've heard about how Sergeant O'Keefe is allowed to basically have haircuts, he can mishandle evidence, he can be unresponsive to emails, he can be anything he says is credible, according to Manager Duffy. Anything Chief Swanson says, no, we're not going to accept that. That's not okay. If you dig deeper into this, it won't take you much. Go look at the police department. Ask some questions. It is in chaos. You are not being given the right information because Manager Duffy his style is not transparent. It is to hide everything. And these things are easily discoverable. And when you look at the other thing is when you look at the standards that are applied to other employees as opposed to Chief Swanson. And again, as I told you at the beginning, homophobia and bias does not have to be proven by someone saying, oh, I'm homophobic. You wouldn't expect that. Everybody is going to deny it. It is about the indirect evidence, the disparate treatment, the way that things are framed, how people are treated. That is the evidence of bias. And you may not like it, you may not want to admit it, but the village of Woodstock has a homophobia problem. And as I told the media, this is not widespread. I am not disparaging the town of Woodstock or the village of Woodstock. This is a few bad actors. And this is something that has been going on in the context of this. Okay. You've heard that Mr. Duffy went so far as to lie in an affidavit that there was no just cause for Chief Swanson, even though his contract says completely otherwise. This is a very serious allegation. If Chief Swanson lied about something that significant, it would be cause for termination. For Manager Duffy, I'm sure nothing will happen. I'm sure there'll be no consequences. He can lie at will. There will be nothing that will happen. You may want to close your eyes to what is going on here. But I'm relying on the appeal. I'm relying on justice to prevail ultimately in front of a jury who will hear all the evidence, not just what Mr. Duffy chooses to share. In a civil case, it will be entirely different, and even in the Rule 75, it will be overturned. I am confident of that. If you do not reinstate Chief Swanson, it will just cause further expense. It will be overturned. There will be, in the next proceeding, things will, in the civil case, we will have more evidence, we will have discovery, it'll be a fair process, unlike this one. The Rule 75 action that will ensue the day after you make your decision will also be fair. And I do not believe in any way, sense, or shape that there is any way that a Superior Court will look at what has happened here and decide that it comports with any concept of just cause or fairness or due process. I am going to leave you here with a quote, and it is a quote from Nathaniel Hawthorne, who knew a little something about witch trials in New England. And here's what Nathaniel Hawthorne had to say. There are few uglier traits of human nature than this tendency, which I now witnessed in men no worse than their neighbors, to grow cruel merely because they possessed the power of inflicting harm. Thank you.
Thank you. Attorney Hicks.
Good afternoon. As we've heard, law enforcement is a distinctive occupation with exceptional demands. As the Supreme Court of Vermont put it, as I said in my opening, generally speaking, we require higher standards of conduct from our law enforcement officials than we might of people in other professions. And that's for good reason. A police chief is a unique role in society in general and a critical leader in this small community in particular. This community needs a dependable leader. Ladies and gentlemen of the Board of Trustees, as trustees, you are stewards of this community. You are the fact finders. It has been and remains your sole responsibility to assess each witness's credibility, to evaluate the documents that have been admitted as exhibits at this hearing, these past 2 days, and the first hearing. Nothing these 2 days or before has changed the material facts that you've already found, and many of them are not actually in dispute. The central dispute at this point, as directed by the trial court, is whether the facts as you have found them are sufficient to find cause to remove, as defined in 24 VSA section 1931 and section 1932. These statutes specifically apply to a police chief, this particular situation. They define the standard for an employment decision. This is different than the standard applied by VCJC. This is different than an internal affairs investigation. The Vermont Supreme Court is the ultimate authority on how to construe Vermont laws. These statutes have been construed by the Vermont Supreme Court a handful of times. The key cases are Turnley versus Town of Vernon and Hubosh versus Village of Waterbury. The key cases are cases that directly deal with the standard identified by the trial court, the statutes that specifically concern police chiefs. The key cases are not BLRB cases regarding collective bargaining agreements. That's just not at issue here. Turnley and Hugh Bosch and other cases indicate that it is sufficient, but not necessary, to remove an employee from the position of chief if that police officer has become negligent or derelict in the officer's official duty or is guilty of conduct on becoming an officer. There are two explicit categories that I just presented that exist in the statute: negligence / dereliction of an official duty and conduct on becoming an officer. If you conclude that Mr. Swanson has been negligent in any official duty or has engaged in any conduct on becoming an officer, removal is lawful, authorized, appropriate, and indeed required. All of the facts you have already found fit into one or both of those categories. For example, Mr. Swanson disobeyed a direct order to remain off premises while on administrative leave unless given permission from Mr. Duffy. Likewise, he shared confidential information with his spouse when there was no engagement that would protect the attorney-client relationship. He instructed employees to sign him in when he was not working. No one knew where he was. He did personal tasks during work hours. Those are not actually in dispute. He chose not to attend court unless it was to observe his spouse instead of representing the community before federal agents or complete investigations. These and other failings go beyond negligence, which is all that is required under the statute. Turning to unbecoming conduct, Mr. Swanson has also harassed and intimidated two employees. He used derogatory language to refer to his subordinates, including the F word on at least 2 occasions. He did not hold himself or others accountable. This is simply not conduct that a police chief should engage in. This is not about bias. It is about conduct. It is about Mr. Swanson's conduct and his choices. These are just some of the many problems you've already heard about and evaluated. The chief must be a leader. The chief must lead by example. No one in the whole community of Woodstock will follow the policies or follow the law if the chief is willing to break or bend when it comes to rules applicable to himself or others. I ask you for all these reasons to uphold the decision to remove and terminate Mr. Swanson from the position of chief via demotion. Thank you.
Thank you. All right. Thank you, everybody. Appreciate it. We will work hard to get a decision out shortly.
I'd like to make a motion to adjourn this special meeting of the Woodstock Village Board of Trustees. Is there a second? Second? All in favor say aye. Any opposed? Motion carries. We are adjourned.